Hey, gun people, this is a pretty good little case, and I might try to do these every once in a while from that point of view that I get in. It gives actual court cases and how they ruled and why they ruled. So to me, thinking like a cop will help even the people that aren't cops how to deal with a government agency if you're ever involved in a critical incident or life or death situation. You have to understand how the courts think, how the cops think, and how the prosecution is going to come after you and how the court's going to interpret that. So if you kind of understand where the court's coming from and how the court rules and why they rule the way they do, and you read enough cases, it puts you in a mind frame of a certain mindset that if you're involved in a critical incident, maybe you're going to pick your words better, maybe your statement's going to be better. Probably shouldn't be given a statement in the first place, but unfortunately, I don't think that's realistic. I think most people are scared, nervous, and they end up talking when they're scared. So, but let's take a look at this case. So this is a U.S. versus Gorman case out of the Ninth Circuit. Now, this court is the most overturned court, but every once in a while, I think they get it right. And in this case, I think they got it right. Under what circumstances is a pretext traffic stop unlawful? And a pretext is basically a lie. I can do a pretext phone call and tell you that I found evidence that's going to convict you and get you to admit on the phone. I don't have to worry about Miranda, and that's called a pretext phone call. It's under false pretense. It's usually not being honest. So they're talking about a pretext traffic stop. Now, pretext traffic stops are kind of iffy. You can do them, but you got to be careful if you get evidence because your evidence is probably going to be suppressed. So a pretext traffic stop would kind of be like sometimes we'd be watching a house and we would think they're running a chop shop or they were doing dope or something. We'd have a car come there, leave, make a transaction, leave. We didn't know what they were doing, but we like, you know what? We want to know who's in that car. So we would call a mark unit and says, hey, I need you to stop this car and ID the driver for us. We're working this case over here. So the cop would get behind him, follow him, maybe wait for him to make a violation and say, you know what, I'm going to pull you over because and there's 1,000 violations. It's easy to find a violation. Let's say he stops you for going left to center or going over the fog line. So he pulls you over, says, can I see your driver's license? Okay, I just want to let you know you want a fog line, have a nice night, and he lets him go. That would be a pretext stop on how to ID. So this case deals with when is it lawful, but it gets a little more complicated than just this. So let's go over some facts here. Nevada Highway Patrolman Trooper made a traffic stop on a motorhome because the driver, while attempting to unsuccessfully pass a truck, caused traffic behind him to back up. So that was his reason for a stop. In response to the trooper's inquiries, the driver, Mr. Gorman, said several things that the trooper believed were indicators that Gorman was transporting drugs and or drug money. And it was apparent, however, that none of these things, individually or combined, supported this conclusion. Now, what that means is he wasn't able to articulate why he believed this. It turns out, in fact, this car was transporting drugs, and the officer was right. However, he couldn't articulate it, and he couldn't convince the court or in his report or anybody else that why he felt that way. He wasn't able to put into words. Okay, after determining that Gorman was not wanted on an arrest warrant and that the drug canine was not available, the trooper checked the database that compared Gorman's home address with residences that have been connected to drug trafficking with the DEA. Okay, so that tells me that DEA keeps a database of all addresses that they think are connected to any of their drug investigations. So the officer checked this DEA database and it came back negative. So the trooper released Gorman without a citation. However, this is where the officer kind of gets into it. The officer immediately telephoned a canine officer in the city located along Gorman's route and told him about his suspicions. Less than an hour later, the officer, who had been watching for Gorman along the highway, spotted the motorhome and stopped it because Gorman had driven across the fog line 3 times. Uh-oh. hey, it's a violation. It's a lawful stop. The courts have ruled that it doesn't matter the intent of the officer as long as the stop's lawful. That's a lawful stop. While waiting for the results of another records check, again, negative, the officer asked Gorman if he was opposed to a canine assessment of his motorhome. Gorman replied that he was opposed to it. If that means anything, it didn't. So the officer walked his canine around the motorhome, and the dog alerted on the right rear fender of the cargo area. Based on that alert, the officer obtained a warrant, searched the motorhome, and found $167,000 in cash, plus pay-and-owe sheets. A pay-and-owe sheet is things that drug dealers keep, saying what I bought the dope for, how much I have, I sold an ounce for $40, I sold this for so. So, it's just basically keeping track of what's paid and what's owed. So anytime we do drugs for sales, we always look for pay-and-owe sheets. So this officer, because his dog alerted, found this. Now, there were no drugs found. And somebody emailed me and said, hey, can a drug dog be made to alert because I had an officer walk his dog around. I've never had dope and a dog alerted. Yes, absolutely. It's called a false alert or false response, and it's very easy for a canine to make his dog false respond. Anytime he wants, he can do it. Usually it's done at the beginning stage of training when the officer doesn't know any better and he accidentally does it. Once he learns and trains his dog, I can get my dog to respond on anything I want by just looking and moving my body and giving the dog a little key that no one else will be able to see. Maybe another canine handler would see it, but most people won't. So was the alert really, or did the officer make him because of what the other officer told him? It's irrelevant because the court rules a different way. So the prosecutors declined to file charges against Gorman because they didn't really have any damn charges other than fake dog alert. But they did file a motion to seize the money. The district court, however, denied the motion, and even if the second stop was lawful, it was intricately connected to the first stop, which was not lawful. So the court ordered the government return Gorman's money and pay his attorney fees. I like it. I don't usually agree with a nice circus court, but on this one, I kind of agree with them. Well, guess what? The government appealed. And in the appeal, we talk about the appeal process. So a traffic stop, like any other detention, becomes an illegal de facto arrest if the officers do not carry out their duties promptly and in a reasonable manner. Now, the courts have ruled you can't prolong a traffic stop to wait for a dog. You can't prolong a traffic stop to have people come by and check it out, to try and make the person agree with you to give you search, etc. If you stop somebody for a ticket, you have to issue the ticket or let the guy go in a reasonable manner. So, this means that unless there is some legal justification for the investigating another matter, officers must terminate the traffic stop within a reasonable time after completing their duties pertaining to the violation. So if I stop you for running a stop sign, I can't prolong it waiting for a dog or seeing what you have in the back seat or ask if you guys can look in the trunk unless I can articulate why I believe I need to do these things. Okay, so as the Supreme Court put it, a traffic stop must be carefully tailored to its objective, meaning you can't go on a fishing expedition is what they're kind of saying. For these reasons, it's obvious that the first traffic stop of Gorman was unlawful almost from its start because, as noted, most of the troopers' questions were unrelated to the traffic stop, and the detention lasted too long. So the court saw that the trooper was fishing and was just trying to get in because he thought the guy was using drugs. Nevertheless, the government argued that the money seized during the second stop was subject to forfeiture because, unlike the first stop, the second stop was not quite so lengthy and unfocused because it was more direct. That's what the government said because they wanted to keep the money. The court said it did not share the government's view, especially because most of the officers' questions were duplicated those of the trooper and were therefore unnecessary. So the courts kind of said, we don't buy your BS. Good for them. In any event, the court was not required to decide the validity of the second stop because it ruled that even if it was carried out in a reasonable manner, it was so closely related to the first, what the court called illegal stop, pretext stop, that it was essentially a mere continuation of it. Now, this is critical because the courts always are ruling on whether something is continuing or not. Hot pursuit, when you use exigency for hot pursuit, there's a fine line on when it stops doing hot pursuit. If I'm chasing you and I lose you, and I continue to look for you, and I set up a perimeter, and I have a helicopter coming in, I have a dog coming in, and I never stop looking for you, hot pursuit exigency still maintains intact and is connected. However, if I chase you and I lose you, and then I go have a cup of coffee and a donut, and then as I'm driving through the neighborhood, I'm like, you know what, I wonder if he went over here, and I go over here, and I try to get in a place saying it was under hot pursuit, I lose it because there was a break in my pursuit efforts. So the courts here said the first and second traffic stop, even though they were separate and there was time between them, because it was predicated by the other officer telling him what to look for and to stop the car, the court connected them. Again, that's thinking like the court is going to be thinking if you're in a trial. In the law, this is known as fruits of the poisonous tree. Obviously, if you plant a bad seed, you can't reap the rewards of the fruit from that bad seed, no matter what it produces. And so this one produced money, but the court says, you know what? It was a bad seed from the first officer stop. It continued to be a bad seed when he called the second officer, and when the second officer found the money, it was still all fruits from the bad seed of the first stop. Therefore, the evidence is suppressed. All right, so let's see. Fruits of the poisonous tree rule that evidence may be suppressed if it was a product or fruit of an illegal search or seizure. On the other hand, evidence will not be suppressed if the link between it and the officer's misconduct was sufficiently weakened, or was it sufficient, removed the taint imposed upon the evidence of the original illegal activity. Applying this test, the court observed the first and second stops were separated by less than an hour. That's kind of a long time, an hour. But anyway, the court said, we don't care if it was 2 hours. He waited. When he got the phone call, it was a continuing crime or a continuing conspiracy or a continued effort on the part of government to follow this guy and stop him again. So it doesn't matter whether it was an hour or 2 hours. Some would be like, well, if you waited an hour and a half, would that be okay? No, it would depend. It would depend on how the court ruled it and what happened in that hour and a half. If the officer left and wasn't working the road, and then he went and had dinner, and while he was having dinner, the motorhome pulled into the same parking lot that he was there and said, hey, and ordered, and as he went out, he noticed the thing had a no traffic light, and the cop stopped him, I do not think the courts would connect that because it was kind of broken. The continued effort to find him was broken. Let's see. Second stop was separately. There was no intervening circumstances that might purge the taint. Consequently, it upheld the district court's ruling. Money was illegally seized. And the court said, give the money back. So the government argued that Gorman's commission of the second traffic stop did, in fact, constitute an independent intervening circumstance that broke the chain. So the government tried to come back because they wanted to keep the money, saying, no, the court, you got it wrong. Judge, there was an independent intervening circumstance that broke the chain between the first and the second. This was a logical argument because many courts have ruled that the defendant's commission of a new crime between the Fourth Amendment violation and discovery of evidence does, in fact, constitute an independent intervening act. So the government was ruling because he crossed the fog line, it was a separate crime, therefore the contact was separate, and it should have broke the two contacts. I think that's BS. That officer would not have followed him, would have not have seen the fog line had he not been following up on the other officer's phone call to stop him. But the court rejected it, and unlike the commission, and it said it rejected it because, unlike the commission of a felony or misdemeanor, Gorman's brief fog line violation was trivial. Amen. Almost all damn traffic stops are trivial. Moreover, the court was not in a mood to be so forgiving, as it indicated by its conclusion that the conduct of the officers constituted a single integrated effort on the police to circumvent the Constitution by making two coordinated stops. I love it. I think the court's got it right. That's my opinion, but again, the more cases that you read on why the court ruled the way it did and how it perceives evidence, and, it kind of irritates sometimes when they go, oh, cops are just flat foot, you don't need to be an idiot to be a cop, and they're all dumbed down. Look, it is legal maneuvering every second of every day that cops go out there and make contacts and make arrests and get involved in court cases and write search warrants and do things. It is a legal maneuver, and you better be willing to defend and cover and back up between the DA, the defense, the judges, the appeal judges. You better be like a midget at a urinal, always on your toes, because the first time you're not, they're going to stick it to you and you're going to look like a dummy. So I think the court's got it right. I think the cops were working in unison, and I think this is a good ruling. But again, it's my opinion. It ain't worth much, but it is what it is. Hopefully you got something out of it. We'll end that there.